The judge did not need to raise his voice. In a packed courtroom, with the HOA board frozen in the front row and folders stacked like evidence on the table, he ordered Cal Mercer to stand. The room changed instantly. Pens stopped moving. Gerald Whitmore, who had spent months looking certain and unbothered, suddenly looked brittle. Beside him, Linda Cross lost the color in her face. Outside the courthouse glass, the brand-new clubhouse still under construction sat on a slice of land that had belonged to Cal's family since 1978. For months, the association had spoken as if the boundary was settled, and Cal was simply resisting progress. In that one moment, all of it began to crack. The original deed, the county records, and one glaring survey mistake had turned a $4 million project into a legal disaster. Cal rose slowly, and the entire case seemed to tilt with him. The people who had laughed at his objections were now staring at the floor. What happened next would not just decide a boundary. It would decide who walked out owning the most expensive mistake in the neighborhood. Long before the lawsuit, Cal treated the 5-acre strip at the end of Oak Ridge Road like a family heirloom. His grandfather bought it in 1978, back when the surrounding land was still trees, dirt, and open sky. Cal's mother guarded the deed with the same care she gave the old photo albums and tax receipts. He never tried to build on the property. He never needed to. He liked the quiet of it, the creek after rain, the old oaks leaning over deer trails, and the feeling that one small piece of the world still belonged to his family. Around him, the HOA neighborhood grew larger and more polished every year. The homes got bigger, the gates got taller, and the board started talking constantly about lifestyle, amenities, and expansion. Every few years, someone would ask if Cal wanted to sell. Every time, he said no. At first, the requests were polite. Then they became pressure. Survey markers started appearing near the edge. Flyers about future improvements showed up in his mailbox. The board president made a habit of treating the lot like a missing puzzle piece instead of private land. Cal did not know how far they were willing to go, but they were already acting like the answer had been decided for him. The first clear strike came on a Tuesday morning. Cal drove past the property and saw bulldozers where young saplings used to stand. Orange flags cut a line through the dirt. A construction trailer sat at the edge of the trees. Survey stakes stretched farther into the lot than any sane boundary should allow. Cal pulled over so fast the tires skidded. Workers told him the HOA had approved the clubhouse and pool complex months earlier, and they kept digging, as if that settled everything. Cal gathered his grandfather's deed, the county plat map, and a boundary report, then took them to the HOA office and later to the board meeting. He laid the papers across the table, page by page, but Gerald Whitmore barely looked at them. Linda Cross kept glancing toward the door, while the rest of the board leaned on excuses about updated survey data and county approval. Then the foundation went in. Then the first trees came down. Then steel framing started rising where his family had once sat in the shade. Cal watched the project move forward in broad daylight, each day making the theft harder to undo. It was no longer a dispute over a line. It was a neighborhood institution building itself directly on top of his land. After that, the pressure turned personal. A code violation arrived for grass that barely had time to grow. Another notice followed for a fence line that had not moved in years. A note appeared on Cal's truck, telling him to drop it. His mail slowed. Neighbors who once waved began looking away. He paid for a private survey out of pocket, and the results were brutal. The HOA's reference point was wrong by nearly 60 feet. That error swallowed almost the entire footprint of the new clubhouse. The association answered with a settlement offer and a gag clause. Cal refused. Then the offer came back larger, and then larger again, because by now the board could feel the ground shifting under its polished confidence. They had built too much, too far, and too publicly. When the court date finally arrived, the only thing the HOA still had left was hope that money and delay could save them. It could not. The courtroom heard the deed, the plat map, the updated survey, and the HOA's own flawed report. Line by line, the mistake became impossible to hide. Gerald Whitmore sat rigid as the judge exposed the boundary error, while Linda Cross stared at the table like she wished she could disappear. Then came the order for Cal to stand. He rose, feeling every eye in the room lock onto him, and the ruling landed with devastating clarity. The land belonged to him, and the structure built on it belonged to him as well. Under trespass and unjust enrichment, the $4 million clubhouse became the HOA's most humiliating loss. The appeal failed. The board was forced to accept that the thing they had treated like their crown jewel was now legally tied to the man they had tried to push aside. Today, the building still stands, but it stands on Cal's terms. The trees are gone, and he still misses them. But every drive past that clubhouse reminds him that standing up at the right moment can change everything. If this had happened in your neighborhood, would you fight all the way to the end, or take the money and walk away?